Hi guys, it's Kathy. I hope you're doing well. So, I don't really have much. I don't have anything. Not only do I have not much, I don't really have anything. I did try. I did try very hard, but it didn't go well. So here's what I'm going to do. Share my screen. I have I have this folder with a whole bunch of videos that I've never seen before. I have to look through yet in it. Um, and I don't know what's in there. I don't know if it's good, bad, or inappropriate or not. I had one clip from McBurney. I did find one. I found one clip from McBurney about this guy, man. He called a lift and then he kidnapped the guy and he made him drive him to Alabama. The guy's fine. He did not get injured. He stopped at like a, a liquor store and a cigar shop. He stopped to buy drugs on the way. And when they got to the cigar shop, the guy actually got away. He drove he drove away and left him there. So so I recorded that, right? And then when I went to get it ready to play for today, there was no sound, no audio. And I thought, oh no. So then I spent a while and I recorded some Judge Wolf while I was doing other things. And I went back to look at it to play it for tonight. And it was completely inappropriate. It's topic matter that I don't want to put on my channel at all. So everything just fell apart trying to get content. So who, Maiko? who's the guy? I'm joking, Maiko. I would fight for you. I would fight for you. Oh my God, yes. Yes, I would. All right, let's just pick. Let's just pick and and see. This is 3 hours long. Let's see what it is. Judge Fleischer? We saw it.
Yeah.
15 hours long. Okay. Okay, this could be good. This could be good. What do you mean a lot of static?
Graded. He had a .128 BAC. And it just about
What about now?
behavior known to humankind.
Am I staticky now? First off, can you hear me? Can anybody hear me? Let's start at the beginning. I see shit show. I told you in Discord this was going to be a shit show. All right, Kelly can hear me. Thank you, Kelly. Am I all staticky? I'm still staticky? All right. How's that? Am I staticky? Is that better? This worked fine yesterday. I didn't touch it. Comes and goes. All right, let's put a court video on. Not this one though. This is a try. Oh, here we go. Maybe this will be better than we thought it would be.
Like they were represented at one date by our office.
Oh, we had enough McDonald's. You can't hear the judge.
All right, I saw that, but then I don't know if the conflict still exists since we're at a revocation stage, right? On that one.
You can come right.
Is this Ms. McDonald?
Can you
You
hear
can
the
call me,
judge
yeah.
now?
Yes, sir. Hi, how are you?
I'm well, thank you. Twenty-four CR 1069, 22 CR 5038, People versus Courtney McDonald.
Daniel Cohen, Bath People.
Josh Lindell, appearing on behalf of Miss McConnell, who appears with us in custody.
All right, we're here for appearance on warrant on a couple complaints to revoke probation. In both cases, the allegations that you failed to report. The public defender's office has a conflict, so we'll appoint the office of the public
My camera's no longer working.
defender, find the conflict, and we'll appoint ADC.
You know what the problem was? I think I tried to order coffee, and
And on 22,
my order was canceled, so I had no coffee. So I went to a different store and I tried to order coffee, and my order was canceled. So I finally went to a different store and I ordered coffee, and it will not be here for another hour, but at least it's coming. And that's why nothing is working. Coffee rules the world.
CR 5038. You were on probation for a class 6 felony. In 24 CR 1069, you were on probation on a drug misdemeanor level 1. The class 6 felony carries a potential sentence to the Department of Corrections of between 12 and 18 months. with a 1-year period of mandatory parole. And the DM1 carries a potential sentence of up to, I think that's old. Is it still 18 months?
On the DM1, it's 180 days.
180 days. Yeah, no. $180 on the DM1. The allegation in both cases is that you just failed to report to probation. You have the right to have a hearing on that within 14 days. At that hearing, you have a right to have an attorney. And at that hearing, the DA would have to prove the allegation by preponderance of the evidence.
You're not gonna believe this, guys. The static is him. I just heard it a couple times. It's not me.
The problem is the attorney, they've got the public defenders have a conflict. So you can insist on having your hearing within 2 weeks, knowing that that might mean you're representing yourself, or that your other attorney might not be able to get up to speed in time. Or you can be represented by an attorney and maybe it goes beyond the 2 weeks that you're entitled. That's kind of where we're at. I'm not going to ask you to waive it right now. We will appoint ADC and we'll see if we can't get somebody in for March 7th. So we'll set both of these for March 7th. And we'll go ahead and set the matter for hearing on revocation for March 14th. At 10 a.m. And so next Friday, hopefully your attorney will be here. We'll find out whether or not you're going to waive the 14 or keep the March 14th revocation. Anything else from the prosecution?
No,
Defense?
nothing further.
All right. We'll see you back on March 7th.
Thank you. Have a good day.
Guess we're going to be trailing the new. For Blair. Yeah, this one is also a conflict. Oh, okay. So, never mind. We didn't talk about it. But yeah. Resume.
I don't see paperwork on Shootman.
There is none.
We vacated a trial because we said we had a deal.
Oh, the judge is not gonna like this. Oh boy.
Oh.
Ms. Blair?
Morning,
Yes.
Your Honor, or afternoon.
I think we're still morning. All right, number 2023 CR 5525, People versus Blair, entries.
Daniel Cohen on behalf of people.
Josh Odell on behalf of Ms. Blair.
He's probably going to yell at both the attorneys here and her and the bailiff. Then he's going to set it for trial, and there is no stopping this trial. Nothing will stop the trial now.
All right, appearance on arrest warrant.
I like Joe.
The allegation is that you were given probation on February 5th. You stopped reporting July 9th. And in the meantime, you've picked up a DF1 out in Adams. You're on F4 probation. I'm disinclined to trail a DF1. We've got to stop reporting. So I think we should just probably move forward on this eventually.
Yeah, no, I just want to raise one thing because I had the same thought, but in looking at the record, I think maybe the failure to report stemmed from her being arrested on the DF1. Just based on the date of offense and when the,
What was the date of offense?
I
I mean, part of it is certainly she's been in custody, but my guess is there was a failure to report prior.
so she had last reported on July 9th of 2024, and I believe I saw that the date of offense on the DF1 was like July 7th, or it was right around that same time frame. Now, I could be wrong, but that was just my view of the situation.
Yeah, right around does not tell him anything. You need to give him the dates. That's a good question, Donald. Do your comments get deleted in anybody else's stream other than mine?
It was filed on July 24th of
He doesn't yell, but he gets real mad.
2024.
Yeah, the date of offense is June. She did not appear in Adams until February. She was writted from Jeffco.
Oh, yeah, I'm sorry, Your Honor. I may have been seeing that the affidavit for arrest warrant is July 24th. So that being the case, I would,
Yeah,
I take that back, and I think Your Honor's right about the failure to report, or at least that there's no need to trail.
Dude, he's already mad you vacated
we
the
try
trial.
to figure this stuff out.
You better watch it.
Yeah. We'll appoint the public defender. What do you want to do, Mr. Lindell?
Yes, Your Honor. I believe this is a conflict situation as well. I'm trying to pull up the old file. I only see this is based on the granted order for a co-defendant conflict, but it doesn't have cited who that conflict is, which is problematic.
Joshua Jacob Geringer.
Oh, no, that was before.
There was a co-defendant conflict in the 235525. Complaints usually don't, for some reason, don't state the co-defendants. They do in Jeffco and Adams. Makes it a lot easier.
I do have a note from November of 2023 that Josh Geringer is represented by the public defender, and that's why the ADC was appointed in this case.
Yeah, with a co-defendant conflict, that should continue through at this point.
All right, then we'll appoint ADC March 7th at 8:30 for appearance of counsel. March 14th for hearing on revocation.
You know, I have county.
That was yesterday. I didn't get it.
Blair just mentioned she has court on the 14th in Adams.
Oh, I didn't get that either. So yesterday when I got off my stream, I fell asleep. So I didn't set up any of my computers to record. Which, you know, normally I have all this content that I look through after I get off work. So I got off work last night. I got home around 11 o'clock. And I started to look for content that I don't have because I didn't record anything. So I started to look in other places and I found like absolutely nothing. And it's all because last night or yesterday after my stream, I accidentally fell asleep. This judge is really good. He really is. He's excellent. Once he gets going. No BS. Go ahead and try to BS this judge. He will call you out on the smallest thing.
All right, then by necessity, because the defendant has court in Adams on the 14th, we're going to have to go outside of the 14 days.
Is there any way I could speak on my behalf?
In a moment.
No, yes, please do. Please. He would love to hear it.
Is she on a writ from Adams?
Here, right? I don't believe you are on a writ from it.
No, Adams dropped my my bond from 50,000 to 20,000. That way I can get out
Well, that's
to
nice.
because I have a job, and
So Adams County,
yeah, they dropped it from 50,000 to a 20,000 bond. Because the judge kind of knows of my situation.
all right, so you've already been writted from Adams. All right, well, we'll see what happens
I
on,
don't think she's written
the
from
7th.
Adams. I think she's in there. I think she's in jail there.
all right, you can talk to him. Oh, don't talk about the case or anything else, but
He wants to address bond. You're on.
Yeah, well, I just wanted to let you know, like, I've been working my butt off to get enough money to get a lawyer, not on the probation thing on my case that I caught. But, so I have a job and I have quite a bit of money saved up, but I also have a 10-year-old and a 15-year-old and a house, that I need to be working for. Right now, my sister's staying there to help, but she doesn't work. She can't pay no bills. And my PO, she knows of the situation that occurred on why I went on the run, because I was trying to gather enough money to get a lawyer on
Ah, she just admitted
the
it.
sticky situation I got myself in.
Minimum effort.
I just really need to be working.
and running from the law.
I told him I'm willing to do ankle monitor
Well, I'm sure you are.
or anything. I just really
But that's beyond the issue right now.
oh,
Oh no, that's not good.
I just don't know what to do with my kids and stuff.
Well, drop them off at a farm somewhere. That's what my mom always said. Hi, Clea.
The only reason why I violated probation was because of
I was on the run because I was trying to get a lawyer. Oh, soup. My chef made this soup. He, the lamb was supposed to come in today, but there was no lamb. So it was not okay. Usually he does really well in soup, but this was just a really thick black gravy, black, with potatoes and carrots and peas, and it was black. Hey, now that my
Yeah, I'm not setting you a bond. You pick up a
oh,
fentanyl case, you're dealing drugs, even working as a middleman is the allegation up in Adams County. You need to put jail time into your cost of doing business.
but I'm not a middle person. I'm not. My
That's
boyfriend.
a whole lot of fentanyl,
No, and it's not.
and I'm not setting a bond on this.
I know.
Think of your children
I just
ahead of
took my
time.
daughter off of fentanyl. That's not something I do. I was
I
dating
agree.
a bad guy, and the guy that I worked for was a bad guy, and I'm stupid because I didn't ask what my boyfriend wanted me to deliver, and then that's what caught me.
Ma'am,
I know, but I'm.
you're not that naive.
No,
I'll see you on March 7th.
Thank you.
thank you. She knew it was fentanyl. Come on.
On mine, I'm reaching out to the attorney on Shutman.
Worcester is a
What's that?
Worcester is a pickup on a parents of arrest warrant.
Mm-hmm.
I tried that with my mom a couple
Do we have
times.
Worcester?
Yeah,
Mom, these aren't my cigarettes. I'm holding them for someone else.
That's also bad. Those are bad.
okay.
I'm always hungry. Now that I like incense. I love incense, and I got this new baby powder incense, but I'm not allowed to use incense when I stream, because Fozzie says it looks like I always have cigarette smoke going into the camera. So I stopped, but my camera's not working. So guess what? Baby powder, incense. All right, next. Who's next? We already saw her. I don't think that's anybody. Or is it pro se? Let's see. Oh, he thinks.
Prosecution's position on bond.
Your Honor, I had the same concerns that the court noted that this is all well and good, but it is incredibly
Late.
similar to what was said last time when he was given a PR bond.
All right, we'll watch it. We'll watch it. JK would blame you for everything. CJ got a new video out, guys. CJ. CJ has it. CJ has the best video she just put out, guys. You have to listen to it. I couldn't stop laughing. Oh, she's reading an instruction manual for ceiling fans. It's so good. Oh my god, it's so good.
You're ready now.
Here, we have Mr. Wooster.
Oh, I missed one. Oh my god, I missed one. I was laughing.
24 CR 4785, People versus Worcester entries.
Daniel Cohen on behalf of people.
Ben Britton on behalf of Mr. Wooster, who is sitting at council table. I would request
That's fine.
he be able to remain seated.
That's fine. Here for appearance on warrant.
Yes.
We previously had a pretrial notice from pretrial prior to December 16th that he was not reporting. And then on December 16th, he failed to report. Bond's already been set.
Are you on
Just need to reset
fire
arraignment.
or just
Your
your
Honor, we would be
pants?
asking to address bond. We do have additional information that came in kind of as soon as he was picked up from a number of people. The people were put on notice for VRA purposes. It sounds like there was kind of an attempt to let them make the record and see if that's sufficient.
And Your Honor, I was notified yesterday of the desire to address bond. I did immediately email the victim. I don't have a direct phone contact with the victim because of the employment. So the primary source of communication is email. I emailed late yesterday. I have not heard back, but in all candor to the court, this victim has never responded to any of my emails. So I don't necessarily know if that's because of a lack of time or if he is just not going to respond, but I have sent email about the request to address bond.
Is he charged with assaulting the peace officer or charged with punching the paramedic?
Paramedic.
Throw him in jail and leave him there. He punched the paramedic.
Your Honor, I can tell you that defense's request is made kind of at the requested urgency of a Chris Richardson with the Denver Police Department who's been working with Mr. Wooster. He actually reached out and gave us a ton of information about what's going on.
It just makes me so mad when they do that.
Well, keeping in mind that he failed to appear September 9th, I set bond at $10,000 surety. Then I reduced it because of Mr. Britton's excellent arguments and gave him another shot at a PR bond. And then he failed to appear again. And then bond was set only at $5,000 surety. So this would be this third FTA.
That's correct, Your Honor.
So go ahead.
Your Honor, so fully understanding that and fully understanding the significance of those three FTAs, I just want to convey to the court the information that I received. This is new to me, came in yesterday and just kind of passing it along. Chris Richardson, who apparently is the director of the Crisis Services Bureau with the Denver Police Department, wrote an email saying that essentially he is well aware of Mr. Wooster, who has been working with the Roadster Recovery Team and wanted to provide context and his personal insight. Mr. Wooster has been staying at the Radisson AIMH site for a while and working with a Peter Dybing and the team to get permanent housing. It's his knowledge that he was granted permanent housing right before being picked up on this warrant. The issue that they're running into is if he's in custody, the likelihood he would lose out on the permanent housing is significant. setting him back to square one with roads to recovery in the services. It says, this is from Chris, we're hoping for possible release. He'd be able to access this housing opportunity once released. On top of that, we're willing to throw any roads to recovery resources we can at him, including case management and connection to possible mental health options.
Well, all this is fine and good. Why did he fail to appear?
Right. And so that's where I was going next. So I then
He was saving money to get a lawyer, Judge.
reached out to the person he's been working with, Peter Dybing, to try and see why there wasn't a connection, what's going on, why there was an FTA. He responded that, well, some of this I think might get into potentially medical stuff that I don't know if I have permission or want to put on the record at this time, but in some,
Oh,
there's
then
significant
Then I can't consider it.
there's significant memory problems, including sundowners, that's left him at times able to track appointments and court dates, at other times unable to, and lost and confused. It sounds like they have been trying to work on an outcome that ensures that he has a way to keep these appointments and remember it, but they do have concerns with his persistent memory problems that are consistently present.
Well, and so he had the same support that you're telling me he'll have now. He had
Good.
that same support last time, yet he still failed to appear.
Well,
And I just need him to show up to court.
and that's
If
what
he's
I've-
not going to do it, because this is basically the same stuff same people.
I have 2 female orange cats and 2 male orange cats. And all of them share one brain cell. You can literally see the orange cat sitting there trying to think, trying to figure out what's going on. They're all, I've had a lot of cats in my life, and I never had an orange cat until recently. And I remember people saying how dumb orange cats are, and they are dumb. I don't even know how to describe how dumb they are. They sit there and they just try so hard to think, and you want to help them, but you can't, because they're just sitting there. They're not going to move until something makes them move, because they're trying to think, and it's hard.
People he was associated with, the same people helping him out. It's the same information.
I mostly agree with what the court's saying in regard to the same people. I'm not entirely sure the timeline. It sounds like he might have connected with Roads to Recovery sometime in the interim from being released last time, because when I spoke with him last time in custody, it didn't sound like he had these 2 people or a case manager or anything else. Additionally, it does sound like from Chris with the Denver Police Department's representation, they're willing to throw any additional support at him that they can. So should he be released, the first thing I would do as counsel is email Chris back and say he needs every potential possible reminder, support, anything Roads to Recovery can do to make sure he's in court. Otherwise, this is going to go very badly.
Slightly.
Already have an offer in the case?
Yes.
Yeah, and that's my recollection. I just don't remember without
The
pulling.
offer is that,
Is the offer changing given the lack of communication?
no. I anticipate we will be able to communicate with the witness victim when we need to. It's just he doesn't respond to notifications, but I don't anticipate having a hard time getting him here for trial.
Prosecution's position on bond.
Your Honor, I had the same concerns that the court noted, that this is all well and good, but it is incredibly similar to what was said last time when he was given a PR bond. We were told that he was going to be on this pretrial diversion program through General Sessions that was going to be sure that he was where he needs to be when he needs to be there. And I don't know what happened with that. I don't know where it fell through, or if the defendant did something to not take advantage of that opportunity. And I have serious concerns about his ability to return to court, given everything that we've heard.
He's thinking. He wants to send him to jail for 14 years like I do, I think. Maybe.
Like, he did absolutely nothing with pretrial, Mr. Worcester. You were given a chance Judge Moses gave you a PR bond. You were given a chance with pretrial. You just absolutely did not do anything with pretrial. I can't leave it up to Roads to Recovery to drag you into court. I can't expect that. I'm sorry it's come to this, but I'm leaving bond set at the $5,000 surety. We'll set arraignment for March 17th, or we can set trial today.
Trial.
I think let's leave arraignment set. I'm going to see if I can speak with the district attorney and see if there's an offer that we could work to resolve this with.
I'm going to set it for March 7th.
Yes, please.
Fine.
All right, we'll set arraignment for March 7th, 8:30.
All right, we're going to take a break real quick, a field trip from Eric. Eric, we'll be right back, okay? You sit there and think for a minute. This is the funniest clip I've ever seen about an accent. We play a lot of accents on this channel because I love them. This is the funny, it's not a court clip. This is not a court clip. This is another clip. Hi guys, it's Kathy.
What
I hope
the
you're
heck?
doing well.
Oh
I
gosh,
don't,
Kelly
I
gets
don't really
right.
can't stand her.
It's pie day.
What the
Make
heck?
sure you eat pie today.
Was that from yesterday?
Chicken pot pie.
Oh my
Pizza.
gosh. Okay, now I got all flustered and lost the clip. There it is. So most likely this is going to demonetize me for this video, but that's okay. Because this video is crap anyway. Here we go.
What's the buttons?
Oh no, they installed voice recognition technology in this lift. I heard about this.
Voice recognition technology in a lift in Scotland. You ever tried voice recognition technology?
No.
They don't do Scottish accents.
11.
Could you please repeat that?
11!
11. 11.
11!
Could you please repeat that?
11.
Whose idea was this? You need to try an American accent. 11. 11.
That sounds Irish, no American.
No, doesn't it? 11.
Where in America is that? Dublin?
I'm sorry. Could you please repeat that?
Try an English accent, right?
11. 11. You for the same part of England as Dick Van Dyke?
Listen, yours then, smart-ass.
Please speak slowly and clearly.
Smart-ass.
11.
I'm sorry. Could you please repeat that?
11. If you don't understand the lingo, away back home to your own country.
Ooh, is that talk now, is it? Away back to your own country?
Oh, don't start, Mr. Bleeding Heart. How can you be racist to a lift?
Please speak slowly and clearly.
11. 11. 11. 11.
You're just saying it the same way.
I'm going to keep saying it until I understand Scottish, all right? 11. 11. 11. 11.
I'll just take his anywhere, you cow. Just open the doors.
This is a voice-activated elevator. Please state which floor you would like to go to in a clear and calm manner.
Calm. Calm. Where's that coming from? Why is it telling people to be calm?
Because they knew they'd be selling this to Scottish people who'd be going off for nuts at it.
You have not selected a floor.
Aye, we have. 11.
If you would like to get out of the elevator without selecting a floor, simply say, "Open the doors, please."
Please. Please. Suck my wally.
Maybe we should just say please.
I'm not begging that for nothing.
Open the doors, please.
Please. Pathetic.
Please remain calm.
What do you want up tonight? Get him up now.
I can't breathe. Oh my God.
You have not selected a floor.
Ah, mules, you cow! You don't let us through these doors. I'm going to come to America. I'm going to find whatever desperate actress gave you a voice, and I'm going to go in an electric chair for you.
Scotland, you bastard!
Scotland!
Scotland!
Scotland! Freedom!
Going up.
That is my favorite clip with an accent. Oh my God. I can't breathe. I can't breathe. All right. Let's see what else he has today. Oh, he's back. Oh. Where's the judge? I love that clip. That's it. Okay. All right. Let's try a different clip. I'm going to delete this one since we saw it. There's 13 hours. Oh, this is... Oh, I turned it. That was Cutie Pie Judge.
Adams County Jail after the allegations of him shooting an ACSO deputy, which has its own consequences. We tried to see if the DAs would move him to Broomfield. They will not. And so we're here 2.5 weeks before trial. We just get information that the gun was swabbed improperly for someone who we have been trying to get impeachment information for because of these issues that she has.
I could barely recognise my own dick. Imagine that. Then I discovered Schaefer's New Zealand style dick sealant. The best way to take care of your dick in 3 easy steps. First, wash your dick with soap and water. Then, wait for your dick to dry. Once your dick is clean and dry, paint your dick with Schaefer's dick sealant. I used to be too embarrassed to invite people over to see my dick. But now, my dick's the talk of the town. I even have pictures of my dick. Check out that dick. I want to send this to my secretary. Barbara always loves to receive my dick pics. After all, summertime is all about spending time on your dick. I'll often have 20 to 30 people on my dick at once. That can really wear your dick out, causing dick splinters and discoloration. But with Schaefer's dick sealant, my dick stays a nice golden brown colour. Who wouldn't want a golden dick? I used to never let children anywhere near my dick. My dick was too dangerous for kids to play on. But it seems like every kid in the neighbourhood's been on my dick this summer, and they've all had a good time. My dick's over 70 years old, but it looks brand new. That's part of the reason all my neighbours are jealous of my dick. Wasn't that right, Jim?
Yes, you've got a nice dick, okay?
His wife is always on my dick, begging me to know the secret of my perfect dick. If you like Schaefer's dick sealant, check out Schaefer's New Zealand style cock. I had a huge hole in my dick, but I fixed it by jamming some cock in it. You'd be surprised how many things you can fix by jamming cock into them. Have an extra large hole in your dick? Try Schaefer's African style cock. Just go to your local home improvement store and ask for the big black cock. Schaefer's New Zealand style dick sealant. Don't put it on your penis.
Don't put it on
There's
your
also
penis.
a helpful number on the back. Hi, I've got a question about my dick. Schaefer's New Zealand style. Hey, get that squirrel off my dick. He knows he's not allowed to come on my dick.
So I have a serious question about that. How do people in New Zealand say dick? If they are talking about their dick, does it sound to other New Zealanders like they're talking about their neck? I need someone from New Zealand to tell me how they say dick in New Zealand. Duck. Oh, gosh. Oh, I love accents.
They say that they had asked for the chain of custody or the CSI reports. I would like to know when and how they requested those. I
have a strong suspicion that I didn't record much of this court. I'm going to check real quick before we sit here and watch half of it. And then I change it. Oh, I changed it. Oh, no, I didn't. I don't know. Well, you know what? Let's just see where it goes.
The actual context was regarding the GSR and drug testing or the DNA testing. It seems that the defense is sort of conflating perhaps that issue, and I think that that's an important one because at no point were we made to understand that there was going to be a delay because of a desire to send it to CBI, or that we were going to wait and consider sending it to ACSO's lab. That's never been our understanding.
Well, that kind of begs the question. You're edging up toward a trial with some pretty serious charges. Did counsel for the people ever make that inquiry that, geez, we're 45 or 60 days prior to this trial and we don't have any DNA? What the hell's going on?
Yeah, that's exactly what we did, Judge. And that's when it comes on our radar about 60 days ago. I reach out to, that's when we first talked to Roz X or Daniel Hill about the testing's going to be done at the ACSO lab. And that's when I asked Miss X, will you please have it done by our deadline 35 days before trial? If these emails are going to come out, which we're perfectly fine disclosing, you'll see in there, I asked her, can you please get it done before our motions date in February? And it was, no, I can have it done by the 35-day deadline. So Mr. Murphy and I had no conversations about where to send the DNA for testing. When we inquired, is about 60 days out, we were told it would be at the lab, and we asked at the ACSO lab, and we asked them, will you please have it done before the 35-day deadline, which they did.
And Your Honor, if I could just supplement, I sent an email to Detective Hill on August 22nd, 2024, regarding the status of forensic analysis, i.e. DNA, GSR, and requesting a status update. He responded on August 28th with the GSR results from CBI, explaining that he's been in a training role the last few months, but has attached the GSR results and sent a request for an update to our DNA lab. I'll reach out as soon as they get back to me. So it's not as though this was just something that we inquired about, even 60 days ago. This is something that we have asked for updates from our agency on. Obviously, it seems that the Detective Hill was, engaged in other matters, including training matters, not to justify any delay.
Well, I guess my question is, did you ever go over there and just, if Detective Hill is too busy to handle his own cases, sometimes you have to take matters into your own hands. What did you all do?
And Your Honor, I did not go over to the agency. No, we received an update from Detective Hill on September 23rd that their DNA lab lead, Roz, had been out for a bit, but she's back now, and that she would prioritize the case, and that there would be a reminder sent. And then there was asking what the discovery deadline is.
So, Your Honor, we had an original trial date of December 9th and a motion hearing of October 4th of 2024. As we were approaching, so that's the day that.
Hi, Walter. It's not. I don't know what we're watching. We're just watching a random video I have on my computer. So try not to get too into it. It could go away at any second.
So at one point it was said the trial date was December 9th, with a 35 days before that, sometime at the beginning of November. Going into that motion date in October, the defense had never filed any motions, never endorsed any witnesses, never endorsed any defenses. They came in October of 2024, motion to continue the trial and waive speedy. So at that time, the trial date is changed till March 24th. The 35-day deadline for discovery changes to sometime in mid-February. And it's those trial dates that are the markers for the lab, as I understand it, in terms of this is our trial date. This is the 35-day before deadline. So I understand the seriousness of these charges in this case. And I'm glad that we got the DNA tested more than 35 days before trial. We didn't ask them to delay anything. We were communicating with them about it to be on top of it. So yeah, we weren't slow rolling any DNA or anything like that, Judge. I expect if the trial would have stayed set in December, we would have probably got those results sometime at the end of October. But the defense came in to continue. It changed the trial date. It changes the deadlines and the information that goes to the labs. And so that's why it got done when it got done.
Judge, may I say something about that continuance?
Once he's done.
Okay.
Your Honor, there's been no willful misconduct here. This was an oversight in a couple of different ways. Regarding the outside agencies, I failed to request those reports until the defense sent us their request saying, hey, this is the stuff we're still missing. Once they did that, we reached out to these places and we got that stuff. I know it's not their job to ask before we act, But the circumstances here demonstrate we're not willfully concealing or sitting on this stuff. You know, and regarding the ACSO chain of custody report and the CSI reports. The CSI reports, for whatever reason in their system, they're restricted. So the multiple times we asked Adams County to send us their stuff, this didn't come through initially. Once we realized that, we got them and disclosed them as soon as possible. This again was my error in not realizing we didn't have them. Now, regarding this report that we disclosed today, which I tried to file with Your Honor just earlier this morning, there were these questions about this chain of custody stuff. So, right, we did ask them to write this report so we can provide it to the defense so that we can give them, clarify this issue of chain of custody or swab taking. You know, that report was drafted yesterday and we turned it over this morning. You know, this chain of custody log, this is not a normal report. It's a living document that is updated as things are checked in or out. You know, the defense asked specifically for more chain of custody information, and we complied with that, and they have that now. You know, the other things I want to say today, to Your Honor, is that I acknowledge we have discovery violations here, that we have a Rule 16 violation. We don't have a violation of a court order. You know, the defense never came to Your Honor, the court, and said, we want an order for these things. We want you to order the DA to produce them. Here, it's Rule 16 violation. I put it in my responses and my supplements, you know. There's no prejudice here. The defense now has the chain of custody log as well as the name of the person who collected the various swabs, noting that the information that the swabs were collected have been in discovery for over a year. Like in our initial discovery packet 1, we disclosed the search warrant for the vehicle, that the vehicle was processed. The affidavit itself discusses the search and the collection of the gun. We all knew the gun was found the next day. We previously disclosed that it had been swabbed. The late discovery simply identifies the person who swabbed it. And no report existed prior to us asking them to draft one here. In terms of the outside agency information, that's all after the fact. These people were not involved in any of the alleged crimes, rather only after the fact. They responded after the incident that the defendant is charged with was complete. And then any of these outside agency officers who were involved in the search and apprehension of Mr. Martinez, they're all on the body cam of the Adams County deputies that were involved. You know, this is late discovery, but it's not late breaking, i.e. on the eve of trial or during trial. You know, we're still 19 days away. There's still a lot of time until the currently set trial date. I went back through the defense motions regarding their claim of being prejudiced, and they say that it caused a postponement of trial. I don't understand that. They had never filed motions going into that first date. They'd never endorsed anyone or any defenses, and they came in and asked to continue. They're the ones who continued the first trial date. They're the ones who continued the preliminary hearing 4 or 5 times. I have never asked Your Honor or this court for a continuance in this case. You know, they did file their defenses here 35 days before trial, and they do have general denial. Also self-defense and defense of property and effect or ignorance of mistake upon culpability. They're saying that this crime was committed, but there's justification for it. These late reports don't go to anything to do about that. So they can't prejudice them. They don't want more time because they don't need more time because the information has now been provided, albeit late. It's feasible to cure any prejudice through a continuance here. A continuance here would be a feasible cure if that's what they were asking for, but I don't think they are because I don't see how it's needed here. You know, have we done anything after the violations to mitigate the prejudice? We have tried. We asked the CSI to prepare this report to explain it. We've given them the most up-to-date chain of custody log. We could run another one if they want to. The type of sanction the defense requests, while aimed at the DA's office, actually punishes the victims, unfairly so. It would rob them of their right to seek justice for the alleged crime. It would also stymie the mission of the criminal justice system to hold accountable those who commit crimes. Judge, I'd argue that there are curative sanctions that the court could impose. I don't think this rises to the level of needing a punitive sanction. This was my mistake. This was my mistake in waiting to make the request. When we made the request, we got it. There's no failure of our system. There's no breakdowns in communication. It was my failure. It was an individual error by the people and me, the representative of the people here. This isn't some pattern. You know, I understand there could be multiple in this one case and that the definition of the word pattern, but in terms of a pattern of across cases or anything like that, I would dispute that and ask the court to reject that kind of thing here. At this time, I'm going to make a fry record. On Friday, February 28th, we emailed the defense attorneys an offer in this case. That offer was to plead guilty to count 2, first-degree assault of a peace officer with a range of 16 to 25 years. We told the defense that offer would be available till noon today, and that offer was not accepted, and so it was rejected. So I will make that fry record. I'm more than happy to answer any questions. I've said it before, I'm extremely embarrassed. We're remorseful about how some of this has played out. We're apologetic to the defense, to your honor, that we are continuing to have these hearings. We think we have it all straightened out now. We have a lot of time before trial. None of this information that's come in is material or exculpatory. It's mainly irrelevant or inculpatory. This case primarily centers around an eluding from Deputy Cooper, a crash with a lay person named Mina Mirabi, running away from Deputy Losh, getting apprehended by Deputy Payton and his dog. All of those people's information was disclosed initially and has been in discovery the entire time, and nothing that came in late goes to any of that.
In a relationship, you can't beg. You got to play hard to get. So play hard to get with a judge, and you'll get further faster.
That information there. So while we did fail to fully comply, we have tried to make efforts to remedy it as we could throughout this process. Thank you.
All right, just for clarification on a couple things. It's been a while since I have taken a look at one of these because there's no reason for me to, but when the DNA results were turned over, was it part of a lit pack as well?
Yes.
And that lit pack didn't contain any information about when or who took the swabs?
I don't believe so. We know that Miss X is the one who did the testing, who prepared the lit pack. She's the one who took the swab. So, you know, it lists the different swabs. I don't believe, and I went through it recently, I don't think in the lit pack, it talks about collection of the swabs. That information is in the chain of custody log, and then it's in additional information in the report disclosed today, talking about how they were collected back in August of 2023.
Okay. Any reply?
Oh, she's about to nail him.
The reason for the continuances that we asked and waived speedy trial and told Speedy was so that we could get this information, including the DNA, which I put on the record, and I put that that transcript in the case. But it is clear that we were waiting for CBI and DNA results. No one told us that they wouldn't be going to CBI. We asked several times. We still don't. We haven't heard anything why we don't have the fire test. They have had an exceptional amount of time with the waiver of speedy and the tolling in this case. So I don't think that waiting to get the DNA results until the exact 35 days before trial is an excuse here. That could have been done at any time. In fact, the new report we had said for efficiency's sake, they were doing the, Rosalind X was doing the swab. So CBI did get us results far in advance of this. And as regarding the lit packet, that is something else that we had to request while in one of these hearings and did not receive with the rest of discovery. And speedy is April 4th. So there's not a time for a continuance in this. They have had the full 6 months this time around. And so with all of that, given the time, there's no continuance to correct it. We cannot test the DNA. We do find at this point it was consumptive based on the incorrect swabbing of the handgun that we just learned about this morning. So we are asking the court to dismiss the case in its entirety. If that court doesn't find that's appropriate, we would be asking to suppress the DNA and to suppress the gun in this case. Otherwise, we would be looking for dismissal of the top 2 charges.
All right. I suppose this is our third day of dealing with the sanctions issues. The court would first find that I expect we could get experts on 4 sides of this with respect to how to properly swab an item. There's nothing to suggest to the court today that there are not samples for retesting, as Ms. France indicated. The defense tried to find a place that could do it more quickly, but apparently that has not come to fruition. And whether or not they're swabbed in properly, I suppose, is something that can be ferreted out in cross-examination. So the court, based upon the timelines here, and I think I articulated earlier that CBI lab, and it's pretty common knowledge, is way behind on their DNA testing. So it's not terribly surprising that it ended up that the in-house DNA lab was going to do the testing, and the court will decline to find that the swabbing and testing was functionally consumptive. In looking at the, I suppose, Gestalt view and looking at all these things, it is alarming to the court that, as I mentioned at the last hearing, that there are folks that were endorsed when the case was filed that would presumably put the district attorney on notice that these are endorsed witnesses and we need to at least try to get something from them. I do find that some of the agencies provided reports and such, but some of them did not, and or did it albeit late, as indicated by the people. And numerous oversights, again, quoting from the people. you know, the fact that the CSI reports are quote unquote restricted is interesting, but not dispositive to the court's view of this. The fact that a chain of custody reports are living documents, well, they always have been. Even back in the old paper days, they were, if somebody checked something out, there was the chain of custody documents changed based upon that. As I mentioned at the last hearing, the district attorney is essentially the chief law enforcement officer in the county or the judicial district. And the court, and you know, I understand that Mr. Houtsma's fall on the sword to a certain degree, but the court finds that there's, in this case, based upon the nature of the case and things that weren't timely turned over, there was what the court would characterize as an alarming lack of due diligence to make sure that the defense was provided with the materials. And I understand that many of the reports had to do with things that happened after the apprehension of Mr. Martinez. But as in almost all investigations into particularly shooting sort of incidents and things of that nature, much of what happens as far as the investigation occurs after the event, and here it would be after the apprehension of Mr. Martinez that evening. And you know that some of the things that the court would find that would not necessarily be exculpatory at first blush, talking about drone videos and Faro materials. But again, those are things that in a case of this nature that the defense should have an opportunity to at least take a look at, and then perhaps consult with experts about different aspects of the case based upon things that occurred afterwards. The court does find that there is prejudice. However, the court finds that the sanctions being requested really would outweigh any benefit or have any real effect that would and the court finds that there have been significant discovery and disclosures, and as indicated, the defense shouldn't have to ask for these things. They're self-executing under Rule 16. They shouldn't need to get a court order for these things that exist and have existed for a relatively long period of time to have them turned over 35 days before trial. The court's going to decline to suppress the DNA results or the firearm. The court's going to impose the following sanctions. The court's reducing count 1 to attempted second-degree murder. I'm striking count 5, which is a special offender count. Witnesses that were not endorsed within the 35 days may not testify, with the exception of Hendrickson, because he basically had a deposition that cures any prejudice. Witnesses that had reports that were authored before January 31st of this year that weren't turned over within 35 days cannot testify to what's in the reports. The testifier was it's typically an important part of the investigation in a shooting case, so the court will not allow testimony with respect to the testifier. So those are going to be the sanctions that the court imposes.
Judge, just a clarification, that I think the second to last thing you said witnesses, I heard January 31st. That's the one I didn't.
Yeah, for folks that have reports that were authored prior to January 31st that weren't turned over to the defense before 35 days before the trial will not be testifying about the contents of those reports.
Okay, and then just to clarify, then, you know, the report we submitted today has information from RosX that was prepared yesterday. So that would not fall under the court's exclusion, correct?
Correct. But other witnesses, that'll be the case. Now, I'm not going to necessarily foreclose that information should the defense.
I would dismiss the case if I was the prosecution. Dismiss the case, get your shit together, and then re-prosecute.
Bring it up, as I noticed in one of the reports, one of the experts was relying upon, at least partially, on the Farrell reports. So if that comes in on the defense side, it can come in on the prosecution side. What else?
Judge, do you want me to file an amended complaint?
Yeah, I think that might be helpful.
Love you, CJ. Have a good night. So we've been watching a bunch of Colorado courts lately with this same problem. And no one is saying what it is. The prosecutors are not handing over discovery in all of the counties. And it's not like he said, the DNA tests take months, so we know that's going to take a while. You can pinpoint that to the labs. Okay, this is not being turned over because the labs take so long. That is not what is happening. The prosecutors are not turning over discovery. But if it was lack of staff, I think we would hear them say, we do not have enough staff. They don't say that. It's just court after court where the defense is just not getting anything. We were day 3 of a trial? It was sometime this week, and they still didn't have all their discovery. They were on day 3 of a trial and they still didn't have their discovery. I don't know what's going on. I love Colorado, the court system in Colorado. I can't see the court system everywhere, but they do some things so well. They have mental health resources all over the place. They have, if people are committing crimes because they're unhoused or they're indigent, they have all kinds of, they're ready to help. They're all ready to jump in and help. Prosecutors, defense, judges. So, I think they're doing so many things right in Colorado. But the discovery is an issue, and it keeps being an issue. I don't know what's going to happen to their case now. If they can't use that, I would dismiss, get everything together, and then go at it again.
And, Your Honor, the only issue left for us is just missing discovery that we're still requesting. So the rest of the CSI reports, we would still like the fire test to see what's going on, given our defense in this case.
Oh, I thought that was provided.
You've suppressed on there. So, no, we still don't have it. Okay, never mind.
No,
Oh,
sorry. We still don't have it. We are still requesting it so that our expert can review it if necessary.
And Judge, we've asked them if there is a report about that, and we've been told there is not.
Okay.
And that person, the Karen Carroll, that's the information we have. We've asked them to triple check. Do you have any report from this Karen Carroll? And we've been told they don't. And I will tell you all, if for some reason I'm wrong again, we will disclose it at that time and we can come back and talk about it. But I don't think there is any more information there.
No, the judge.
All right.
No, the prosecution can dismiss their own case. the prosecution should dismiss this case right away, and then refile.
Before you continue, Ms. Miller, I think I do need to make this point.
Okay.
To a certain degree, the court is finding blame with the district attorney's office. However, that being said, and this is just my own thoughts, but it is usually, particularly when you have, in particular, a shooting where the victim is a member of a specific law enforcement agency, to have that law enforcement agency do the whole investigation, probably in at least some jurors' minds doesn't look terribly clean. That being said, however, that was the case here. The Adams County Sheriff's Department led the investigation, and it was their jurisdiction, and I understand that. They have every right to do that. But I think what comes with the right to do that, and I'm not disputing that, I'm not saying that's the wrong way to do it necessarily, but I do think that it puts an extra onus on the lead detective or detectives who are investigating the case to make sure that things are handled timely and appropriately. And based upon what I've heard over the last several days in this sanctions hearing, that was just not done by the in an efficient manner for a case like this by the investigators from the Sheriff's Department. And yep, ultimately that falls on the lap of the district attorney. But I guess I would say that whether or not Detective Hill is in a teaching capacity or on FMLA, that might be the time to hand it off to somebody else to make sure that things get done and get done in a timely fashion. I understand those are explanations, but I don't find them to really be excuses.
Oh, yeah, sorry. And the last piece I have just to request, in paragraph 17 of the district attorney's response to motions for sanction, they discuss about different information they have looked or received about Rosalind X, and we would just like that information as well.
Well, I think I pretty much already ordered that, so.
Okay, we have not received it.
I guess I need clarification. I'm wondering what.
If there is other information that, and I think the motion says there you looked and there wasn't any.
Right.
But in the letter refers to some different things. If those things actually don't exist, that's the case, and I expect folks can certainly get the. Because really the same issue, the transcript of Deering is available for cross-examination, and it was covered pretty thoroughly.
And the information I put in there came from Mr. Redmond, that was his helping me to answer that question, that has been thoroughly vetted and determined there is nothing else there. So I don't have anything else to provide about that.
That was my recollection. My recollection of that testimony was that the issues that the collateral issues other than the unauthorized, if you will, dissemination of an investigation that was still open, which is not allowed, was coupled with really what the court would characterize as the witness's snarkiness with other employees. That's really what it ended up being. It created an environment that was not apparently terribly great based upon that. And snarkiness is probably not critical. I think might be in there somewhere. That Ms. X was being critical of some of her coworkers' performance, and that didn't go over very well.
And I think my concern was just that it said that it was found, the complaint, I don't have it.
And the complaint, whatever the sanction was really about the training that was put on by Ms. X with materials that were not supposed to be disseminated to the public.
Okay. And this one, it says that the motion to compel was based on unsubstantiated complaints. And I'm just wondering.
Disseminated means destroy 1/10 of something. And they disseminated it to the public?
Where that's coming from. That's the information I'm looking for. And I have not seen the transcript yet, so I don't know if that was discussed or where that comes from.
Or maybe disseminated is just something
Oh,
different.
you're welcome to get it.
Maybe I should read the dictionary
The
again.
transcript I understand, but this is something that the DA in the
Decimated.
motion said that they reviewed and saw. But
Decimated.
the unsubstantiated complaints, and I just would like that information
Disseminated.
that he's using.
Disclosed
If that's a
evidence.
transcript, maybe we just
Decimated.
request the transcript so we don't have to rush
Kill
over
10
it.
people.
Anything other than the transcripts and Mr. Redmond's memory?
I don't believe so.
All right. Well, it looks like it'd be in the transcript. And it's been a while, so I don't remember it. The testimony, of course, verbatim, but I remember the gist of it was at least some of those complaints by fellow employees about Ms. X were found not to be and I don't know what their level was, whether it's a hostile environment sort of thing or whatever, but some of them were not found to be in that genre.
Yes, and that's not what the ones we'd be looking for. So understood.
All right.
Like the cold.
I guess the people now have been provided with the summaries of the defense experts. Anything you want to tell me about those on behalf of the people?
No, Your Honor.
All right. Well, what came to mind when reading one of the summary reports was, and I know my musings may have gone too far, but it's kind of along the lines of, I'm trying to think of the name of that case. Law schools, a long time ago, but it's coming to a nuisance. And it's probably illustrated a little bit better in there's a string of cases or a few cases in Colorado that talk about heat of passion that indicate that if your wife has or your loved one or former lover or whoever has a protection order against you, and you think that the offender thinks that she's in a new relationship and sneaks up and looks in the window and sees the former.
Oh, she is. She's cheating. Even though you're not in a relationship anymore, she's totally cheating on you.
Significant other with another man, that might provoke a heat of passion, but the offender created that. And I guess I'll cross that bridge when I get to it.
And Your Honor, we will still be trying to get an expert we're going to ask if we can get these swabs tested. So if we can, great. If not, we understand that with the timing we have. As soon as we have any experts or reports regarding any DNA testing, we'll disclose those.
When are we starting?
The 24th.
Everybody, JK. Everybody. All right, I had enough of this
Well,
guy,
absent good cause, those,
That
I'm
was
gonna
good.
say those need to be turned over.
but they're not fighting anymore, so. I'm pretty sure we saw this. I'm just so sure. I'm 100% sure, actually, so. Let's go to March 10th. Okay, Connecticut. Let's see what Connecticut gave me. Oh no, that looks just like lawyers. Alright, let's see what it is. It looks like just lawyers, so this is probably going to be quick. I'm going to turn it off.
Strike, I believe it's your motion, Attorney Berube. I'll hear you.
Yes, thank you, Your Honor. So before I jump into the argument, I think there's two important facts just to relay about the case. Again, this is not a case about an insurance claim dispute. There's no insurance claim at dispute in this case. And second, the gist of the plaintiff's allegations in this case are that plaintiff had a policy with Nationwide, that the policy was canceled by her in 2022, and that a couple of years later she discovered, as she alleges, that premium payments were taken from her account. Continue for that period after she came.
Yep. No, thank you. No, thank you.
For doing the out-of-county,
Saw it. We saw it. We saw it.
I'll make it $37 a month.
Okay. Child support. Let's go to the next person since we're already halfway through this person. Actually,
And then health and reporting orders, I will
I'm going to run to the ladies' room, so I'm just going to let it play. Be good. I'll be right back.
make mutual. All right, that will be your judgment.
I have one more question. Is there any way we can set up to like for a drop off, especially like specifically
Oh, wait, I'm sorry. Say that
for
again.
drop off? So like when I drop the kids off, because I usually on the weekends I pick them up from their house and I drop them off at their house.
Are you asking if she could pick them back up from you or something?
Or if we can meet halfway, maybe somewhere in between the
Where do
line.
you live?
I mean, I don't live too far, but sometimes it is a hassle through traffic and everything. But I mean, it's like a daily commute, like everything. It's like maybe 20 minutes.
Where do you live?
On Marysville and Rayleigh's. over by
Okay, where
80.
do you live, Mrs. Scott?
Off of like Arden and Fulton. Well, Howe Avenue area. It's not. I don't mind meeting halfway if that's
Okay,
what he
I'll
wants to
let you guys
do.
work that.
I mean, she said that before, but it's always been a hassle. It's always some kind of excuse. I mean,
No,
it's
it's
true,
the way
but-
you. It's the way you
Well,
act.
but this is just on the weekends when you're taking them back, right?
Oh, I mean,
Because you're
sometimes-
picking them
yeah.
up from school.
Yeah, and I'm dropping them off too.
And I understand. So, but she's saying that she's willing to go halfway to get them back.
Uh-huh.
Well, you don't think she's going to go the halfway to get them back?
I'm not sure.
It's not like she's going halfway to give them to you.
Because there's been times where I dropped them off and she's not home either.
Well,
But there's someone here
That's
to watch him
well,
until I
but this
get
will be, if you have a halfway spot, I mean, can you pick a place?
Yeah, we can pick a place.
Where? Arden Fair Mall?
Wherever, I mean, what's easier for her? Because
You
there's
can meet by the
way-
Chevron on Marconi if you want. That's closer
That's-
towards you.
Yeah, that's fine.
Okay.
Chevron on Marconi.
And that's I had another question about that, kind of a concern. So if I go to drop them off, and I'm intending to directly drop them off to her, correct?
Yeah. You're not planning on having anybody else there to pick the kids up, are you? Mrs.
No,
Scott?
I mean, if I was to have something to do, if I'm still stuck at work, my sister, and he knows my sister, and it's never been a problem for her to help him out to pick them up when he didn't.
Oh, but I'm saying after I take them back. That's not the issue during or anything. I'm saying after I drop them off.
What's the issue then?
Then sometimes I drop them off and she's not there.
That's okay, as long as she has somebody there to take care of them.
That was one of my questions.
Yeah, I mean, it's just when you have them, you're responsible for taking care of them. It doesn't necessarily have to be you.
Okay, understand.
So meet at Chevron on Marconi for the weekend drop-offs, right?
Okay.
Okay, that's it.
Thank you.
Thank you.
All right, thank you.
All right, bye-bye.
And I'm sorry, Honor, what was the final determination on timeshare?
15.
15, okay.
Yeah, she said he's picking them up from school 4 or 5 days a week and having them one overnight, not every week.
Who misbehaved? Oh, Kelly's here. Never mind. She had it under control. Oh, Donald, you're back. Donald, you missed a very pretty, blonde attorney that you didn't get a chance to make a comment on. And we all noticed that you didn't make a comment on the pretty blonde attorney.
Again. So I just eyeballed it. It's about as good as you can do with a schedule like that.
Understood.
But it was clearly more than 10%. And way less than 50. Okay. Oh, we had 3 more people in the waiting room.
Yes, and we'll move that calculation as
Don't have to. I just printed it.
but we still need it saved if you.
Oh no, I just saved it. No, I wouldn't keep it.
got it.
I wouldn't keep it secret from you.
Well, I'm just saying, sometimes we need to recreate it down the road and.
All right, number 6, since we're
Okay.
dealing from the bottom for now 3 cases in a row.
I mean, they can, because there's no real, rules. But they don't, because we like each other and we don't want hard feelings. Listen, everywhere we go, all day long, we have hard feelings. It's just crap out there. It's crap no matter where you go. But when you come into here, you don't have to worry about that crap. You can just watch court videos and laugh and joke about pizza and you don't have to worry about all that.
Also a judgment.
This is also mainly timeshare.
Well, hopefully it's about as bad as the last one. As difficult. I mean. Okay, so Dre Johnson. Good afternoon. You're muted. Yes, you are. Unmute. There.
Okay. Yeah, good afternoon.
Ms. Vincent, you are muted also. *6. Or you can just listen. That's fine. Oh, there you go.
Hello,
Say hello,
I'm here.
Ms. Vincent. Okay, good.
Good people.
So we're here for a judgment. There is voluntary declaration of paternity. So that establishes that you two are the parents. I'll join the mother as the other parent to this case and enter the judgment. So, Ms. Vincent, how much time do the children spend with you?
So usually, ever since I moved out of his apartment, it usually has been 50-50. And then it'll be some days where, if I have an appointment or something, I'll be like, hey, can you keep him an extra day or whatever? But then when he does keep him an extra day or whatever, then when I have him, I'll keep him an extra day. And then, but as of recently, he's been refusing to drop off Adrian because like him and my mom, they go back and forth talking about how, I'm in a new relationship. So every time he hears something about me and the person that I'm in the relationship with, he refuses to drop off Adrian. But originally, it has always been 50-50. He keeps him a week, I keep him a week, and it's just been like that.
Is that right, Mr. Johnson?
I could say last year, we had 50-50 for 4 months straight. It was like that, but then she just fell off the map with just being consistent with him. But
Well,
yeah,
what 4 months was that?
that was last year, and that was
Yeah, but last year was only 2 months ago, or less than 2 months ago. Well, a little more
so
than 2.
I would say
JK, thank you so much. I really, really appreciate it.
from April all the way to August is when she was consistent
Okay.
of being 50-50. Other than that, it's been me like 95% of the time. Even now, I don't know what she's talking about her being in a new relationship. The reason why, because that's definitely not it. All I asked her was for 10 days out of the month. If she couldn't give me 50% of the time, give me 10 days out of the month, and I can keep them to 20, 30, 20 to 21 days, and I wouldn't have to go for child support. But since she's not consistent, that's why I'm going for child support, because I have them 95% of the time. She only seen them 2 days out of this whole year, and we're going about to go in.
Actually,
One
we're
second.
asking for child support from you, Mr. Johnson. Is support signed?
Yes, Your Honor, and we do have an EFDP by the Department of Human Assistance where father indicates they're going back to 50-50. So if that's not going to happen, then mother does not need to be receiving aid for this child.
Oh, so wait, what's going on? I'm the one who applied for child support.
No, you're not.
I do the same
She was
thing.
on cash aid. When she signed up for cash aid, that's an automatic referral to Department of Child Support
Okay,
Services.
so there must be some type of confusion because I literally just put it in. So I didn't know that.
This
I didn't know that she
wasn't
was,
just put in. This summons and complaint was filed in November.
Oh, okay. I thought it was because of my behalf, because I'm the main guardian, the primary guardian of Adrian.
No,
So
and it's asking for you to pay support, Mr. Johnson.
Oh, so yeah, there's some type of confusion because I shouldn't be paying support at all. It should be the opposite.
So again, a father opened a case after DCSS started pursuing father for support because of the aid. The Department of Human Assistance conducted an investigation and they did not discontinue the support based on the parties. I mean, the support, they didn't discontinue the CalWorks based on the parties indicating they were going back to 50-50. If that's not the case, then I am unsure as to why father would say they were going back to 50-50.
Yeah, no, when the guy had told me about the 50-50, it haven't been 50-50 in 3 months since I talked to the guy. When I told him like it probably won't be a good idea to say 50-50. We're going back to 50-50 until it actually happens. And it has not happened.
Your Honor, if the court is inclined to find different timeshare to 50-50, we could get that on the order so we can provide that to DHA.
Yeah, the question is back to you, Ms. Vincent. So this year, how often have you had visits? Ms. Vincent? Are you there?
Right.
Well, Mr. Johnson, one thing that I know, and that is, or at least what I'm told, is that she has no other income other than cash aid and CalFresh.
From what she told me, she had a job and she just got an apartment. So I don't know what lies she's perceiving. And
that she might have housing assistance. I don't know.
Well, she told me she had a job. She just got a job just a month ago. That's what she said. And that's coming from when I dropped her off. Well, I dropped my son off to her mom, and then I guess she got into a fight with her guy or whatever the case is. She got into a fight. She went to her mom's house. She stayed there for 2 days. I dropped the baby off, and she only seen him for 2 days this whole year. Like, I'm the main primary custody of the child. His doctor's appointments, that's all me. His dentist appointments, that's all me. Like, I don't know what anyone means about 50-50, but when it comes to this child right here, I have
Okay,
other
all right.
children.
So, Ms. Vincent, you need to unmute yourself.
She left.
She did.
Yeah, of course she did.
So, Your Honor, if you want to hear what the department found regarding her income and.
Yeah.
So we ran the work number for both parties, and she was employed until February 15 of this year. So she shows up as inactive moving forward. So I don't believe she has.
Inactive from the employment?
Yes, she was with them from December through the mid-February. And looking at CalSAW, she is active welfare to work. So perhaps this would be a mutual zero order.
Sounded like. And you're paying child support for another child, sir, is that right?
That's correct. I'm paying child support for two of the children. And this is the only child I have 95% of the time. Even while working, I have my grandma watches him. Like, I don't get really any help from her. And I didn't even know this was still considered the case from November for her applying for welfare. I thought I put in a case for child support because if anything, I need child support, some type of obligation from her because she's not doing anything for him. It's only me.
But she has no income since middle of February.
Right.
And I'm showing that even if you had 90% custody under the circumstances, you would still owe her a little bit, but that's in part because her income is cached in CalFresh. I am not inclined to order you to pay any child support. So I will make it a zero order both ways.
Okay, Your Honor, I wonder if, so we have an outstanding summons and complaint against mother. I can give you the docket if you want to dismiss the S&C over there or enter the zero for her under that docket.
Now let's go ahead and just get rid of it.
Okay, the docket is 24FS 02453. She was served February 22nd.
Okay. So if your office can just let her know that we've dismissed it.
And the mutual zero then is going to
Salty, I've never met a man that's not allergic to him, though. They all tell me they're allergic to him.
be entered under the 2413.
Correct.
Okay.
And mutual on health and reporting orders.
I just want to check, does father understand why the court could not enter an order against mom? Did you understand, sir, what the situation
Yeah,
is?
well, I understand that because she's supposedly not working right now. And she's on welfare, that you guys can't like put that type of stipulation.
No, they're going to stop the welfare.
Oh, they're going to stop it. Oh, okay.
Yeah, based on what I'm ordering today.
If circumstances change and you find out she is working, we can always take another look to see if we can modify the order.
And they can do it in this case.
Okay, I thought she was working, but if you guys check, like the workforce system and show that she's not working, then I'm only going based off of what she tells me, and I don't know if it's the truth or a lie. So I can't call that. But if I get a whip for where she's working at, then I will definitely try to see if I can get some type of justice here, because
that doesn't make sense to me. This all doesn't make sense to me. So when the roles are reversed and he's not working and she has the children, but he's able to work, then they put him in as minimum wage. and he has to pay that. He has to pay at least minimum wage worth of child support, or he goes to jail. They should put her in as minimum wage. They should put her income in as minimum wage, and him 90%, and his income, and figure it out, and she would owe him something.
Like I said, she's not. I need more obligation from her as a being the other party parent. It's like literally, I'm like 95, 96% sure that I have this child the majority of the time, and it's only me worrying about him.
Yeah,
So,
well, and it seems to me that it would be beneficial for you to have some help, even if it's just having the child.
yeah, even if it's just like, right, exactly. And I wasn't trying to ask for a lot. I really wanted her to be 10 days out of the month. I tried to come up with an agreement, 10 days out of the month, and I'll take the 20 days, if she needs, and if she still wouldn't.
I am here to testify that the father does not always take it in the shorts in family court. That's just nope. No, they don't. Yeah, they have to pay money. Fathers have to pay money when they leave the kids. Yeah, that's terrible for them.
Agree to that. So,
All right. Well, then what we can today. Good luck to you.
Okay. Thank you.
All right. Bye-bye.
And Your Honor, if we can get that timeshare information on the order, that it's not 50-50. Okay.
All right. So number 2. Hello, Ms. Roberts.
Hello,
Are you at work?
I am.
Okay, this shouldn't take too long. Besides, Bruno, I don't have an income and expense declaration from the father. Did you get one?
No, we didn't get it. Mother is the payor in this case. Support was set at 428 last time. We asked for an income and expense declaration for her. Just looking at the work number, we see the support going up based on the work number profiles for both of them, but father is not here.
For myself, my pay has went down dramatically. The only reason why my pay was so high was because it was during the holiday time. I work retail, so that's why I was getting paid so much. But now I'm not getting paid like that anymore.
How long
Plus,
have you worked
also, with almost.
How long have you worked where you are?
I've been working here for 3 years.
Okay, so what do we have for 2024 income?
I mean, I could give it to you, but last month I made.
See, that's the thing.
Probably.
You say that because of the holidays, you were making a lot more and you don't otherwise. So that's why if we use a 12-month average, it will include that good month or two, but also the other 10 or 11 months that aren't as good.
The problem with 2024 for mother is that she also has periods of disability, so it's not all straight wages from her employer.
Oh my God, I got some of those. I have to try them. They're magnetic. So you use this little tool to put them on, and then they stick together and they're real hard to get off. I think I'm gonna try. I think I'm gonna wear them soon.
And then also another thing too for myself, I do take care of my son. He does come to my house. I provide diapers, like food for him. I've discussed this with you before.
Different case, different.
And it's just a lot. Then, I mean, it was a lot. I mean, I'm just asking for maybe a little bit deduction, just like a little bit, like maybe 350.
So, Your Honor,
when does he visit with you?
I visit him twice a week.
Overnight?
Not overnight yet, but he comes to my house.
How do I remove this from?
So how many hours do you spend with him a week?
4. Plus, I have another child, Bella, that I visit with 2 hours out the week. It should be increasing because I should be within 90 days. I should be having them home.
You're talking about the other child? And it's
Yes.
just Dwayne, not Erica?
No, it's Dwayne and Erica, but I have other kids outside of them.
No, I understand that. So you still don't spend any time with Erica?
No, they don't. He does not let me see them. He's refusing to let me see them. He called me a couple of weeks ago, and he discussed with me that he was going to stop child support. And then literally begged him for me to see my children. And then I had set up supervised visits where he refused to let me see them. And so I guess I'm going to have to go to court and
It's correct.
try to do something else because he's refusing to allow me to see the court order petitions. Well, I'm scanning his face on that shit.
So Your Honor, would it be appropriate to just confirm the existing order? Since father is not here to make the request of higher support, and then we didn't get a pay stubs or an I&E from mother showing any deductions.
Didn't we have that last time?
I'm sorry, I'm getting some background noise from.
Didn't we have that last time? I don't show that there are any deductions for her.
There are deductions.
Well, no, I'm talking.
We
know you paid federal and state taxes, Social Security, state disability.
I pay rent, I pay everything.
And no, I'm talking about union dues, health insurance premiums, and retirement. Those additional expenses you do not have. Everybody has housing expense, transportation, food, clothing, all of that stuff. The guy like calculator.
I'm just reading your last order after hearing, and mother was specifically directed to file an I&E with the court and DCSS, and we didn't receive that.
So what I'm doing is using the same information that we had at the last hearing, changing only because of the 2% timeshare with Dwayne.
Okay.
Everything else is staying the same, except the child support goes down a little bit.
When would you like to make that effective?
So when did you start having him the 4 hours a week?
Huh?
When did you start having Dwayne 4 hours a week?
No, I haven't been. He has not been letting me see Dwayne. I have my other kids.
I think mother is articulating 0% with the kids with Mr. Robinson, but she has another child that she has.
Yeah, no, I heard about the other child, but
yeah, with Dwayne and with Erica, he refuses to allow me to see them, even under court order.
All right. So take him back to court. When you file your request for order, check the box to revisit child support. You'll have your custody and support hearing on the same day. So at this point, I'm going to confirm the existing order.
Okay, but we specifically set another court date because I told you my income was going to be getting deducted. It's not the fact that I'm not getting vacation. I'm not getting holiday pay anymore. I'm not getting all of that. That was for November and December. Okay, so during the November and December, I was getting almost $1,600. I don't get that. I only get like $1,400 a month. And you're taking $400 plus my rent is increased to $1,000. I don't have anything to feed myself nor my other children.
I'm gonna slap
I'm
this
asking you if
woman
you could just
so
And I don't have any basis for doing that. Nobody provided updated information.
I could give you pay stubs. I could give you
Well, this isn't the time for that. He's supposed to get a copy also before I see these. I'm just confirming the existing order. There's no way for me to do any more. File your motion.
Your Honor, please.
File your motion. That will take care of it.
So what motion is that I have to file?
It's a request for order You can get in touch with the Self-Help Center and they can give you information about how you need to file that. They're here at the courthouse. So go to the Sacramento Superior Court Family Law website and you can talk to them by email or by the phone or come in person any day but Friday. All right.
How much you want to bet she files this motion, if she does, and her support goes up? My ex did that a couple times. He filed to get support lowered. Okay, for 3 kids, he was paying something stupid like $90 a month. And, you know, he worked, I guess. And he didn't like that. So he brought it back in. He said, I can't pay $90 a month. I can't pay it for 3 kids. And it got bumped up to like $200 a month. And I thought, okay, $200 a month. I was living the large life. $200 a month. Well, then, after a while, my eldest turned 18. And and instantly, like, he had that case filed way before she turned 18. He was like, okay, October 25th, let's go. Let's have the court date right that day. So we go in, and and it was upped to like $300 a month for the next 2. And then, so I got the next 2. Year and a half later, my next one turned 18, so he was right away bringing it, because he was thinking that, they turn 18, they get dropped off, his support will get cut. Well, no. His paychecks went up. So when the next one turned 18, he dragged me in right away, right away. Let's go. Let's cut this out. Well, it was upped again. So for my last child, he paid more for my son than he ever paid for all 3 of them together. It was awesome. It was so good. And the best part, it wasn't good when it happened, but the best part was he didn't make his child support payments. He never did. So his arrears were so bad that way after my kids turned 18, he still had to pay me child support for all the arrears he had.
That's all for today.
So let me ask you a question. So can I ask you a question, Your Honor?
Go ahead.
So why did we set this court date if you were going to see about my additional income?
So
the income.
What do you mean, Salty? You mean $90 a month is not enough for 3 kids? Are you sure? Are you sure $90 a month is not enough for 3 kids?
So we could see your income was and what his income was and revisit the support if we needed to. I didn't get any information about any change in your income or his income. I have nothing. You were supposed to file expense declarations. Didn't happen.
Oh, I thought you guys pulled that up. I didn't know that I had this.
Yeah, everybody does. Now, when you file your request for order for custody and visitation and support, make sure you file an income and expense declaration with that. Then you'll be fine.
Okay, so I could do that like in a couple of days or something?
Yeah, you could do it today if you could get down here and get the paperwork.
But how soon will it take effect?
Well, as soon as you file the motion, as soon as you get more time, then it'll take effect. So probably the same time as the hearing. So that'll be about 2 months. All right, good luck. Bye.
All right, guys, this train wreck is over. We made it. I had 0 content ready, and we just did a 2-hour stream. No camera, but that's okay. I enjoyed it with no camera. I was scratching things and chewing on things and all kinds of stuff, and there was no camera, so I could. I'm not going to do OJ today. I almost was. I really was almost going to. But I got to work a double soon. And I think I'm going to go to sleep. Since nothing's working, I'll do OJ tomorrow. Look, he has blue eyes, Donald. There you go. Sexy mama. Arr. Thanks, guys, for making this a great, great, great night, even though it wasn't. You guys are awesome. You guys are so good. All right. I'll talk to you guys in a little bit. Behave today, okay? Because there's no judges tomorrow. It's Sunday. Well, today's Saturday. Yeah, I said that right. Bacon. Bye, guys. Thank you so much. I'm going to, Eileen. Thank you.